Hello, welcome to Lawyers Infohub. It's always a pleasure to create content on this platform. If you're new on this platform, you're very much welcome. I'm Mercy and I'm your host on Lawyers Infohub. For my returning subscribers, I always thank you for always checking back on the channel to know what is new, what we have dropped. I am very grateful. So today we are looking at innovations in the Supreme Court Act 2024. Yes. Now, I know many people don't have it. You need to have it. Are you a lawyer who is abreast or who is willing to be abreast with the trends in our system, in our profession? You should have this. You should have a copy of all the rules of the several courts that we have. It helps you. You can never the cases you have and all of that. So this is a copy of the Supreme Court rules of 2024. So we're going to look at the innovations. What are the new things that were brought in that was not in the old one that was repealed? Now, these rules came into force, you know, on the 15th day of August of 2024, but it became public on the second day of October 2024. So we're going to just go through it and check out what is new. So these new rules is an overhaul of the old one that had lasted for over 40 years. Yes, because it was the Supreme Court rules of 1985. So this is a total overhaul. And this is in tandem with the new technology driven legal practice we've been talking about. So I commend it is really commendable. And you must also note that it was under the administration of Honorable Justice Ariwola that it came into be into it came into force. Yes. So let's go into it. If you're yet to subscribe to our channel, please consider subscribing to the channel and you enjoy every bit of your time on the channel. We have several videos that has discussed several aspects of law, the different branches, areas of law. We've talked on almost all branches of law. So just relax, take your time, go to the channel, you enjoy yourself. Now, one of the new things that was introduced in the Supreme Court rules of 2024 is electronic filing and virtual hearing. In our time, one of the blessings of this time is technology. And in every area, even in business, people are trying to put a factor in technology in all they do. So I'm glad that the rules captured the fact that you can do electronic filing now and that virtual hearing is now possible. The idea is to see ways that the cases can be congested because in Supreme Court, you see have cases of 30 years, 40 years, 25 years, be wondering when would they finish it. But with the technology, if it's utilized in the way it should or the way it is being projected, I think it will help in this problem. So the rules made a very significant advancement in terms of creating room for electronic work filing and virtual hearing. Change order 17 and order 18. So but basically, order 17 rule 4 sub 2. Order 17 rule 4 sub 2. Let me read it out for you. Let me read it out for you so that you can hear it properly. Now, it's saying that the chief judge shall periodically issue practice directions to provide for the manner and form of electronic filings and the administration of electronic filing systems of the court. That is Order 17 Rule 4 sub 2. Then Order 18 Rule 8. The chief judge may periodically issue practice directions for the regulation of virtual hearing. So he's talking about the fact that the chief justice uh, periodically from time to time will issue directions as to how the electronic filing will go, how the virtual hearing will also go. When virtual hearing involves a lot of things, the procedure, how to go about it. I know when you talk about Supreme Court, the voluminous nature of the matters and the files and all of that. So the periodically the Chief Justice are empowered by the rules to issue practice directions on how it will work. That is one of the key innovations of this new uh, rules of 2024. Now, another very important one is with respect to the proof of argument. Now, the new rules, Supreme Court rules of 2024, reduced the time frame for filing of the appellant brief. Before, we used to have 10 weeks from the date of receipt of the record of appeal. But now, from that 10 weeks, it has been reduced to 45 days. Yes, 45 days from the receipt of the record of what appeal. That is under Order 16 Rule 2. Once you receive your record of appeal, you have 45 days to file your appellant brief. Now, for respondent brief, it used to be um it used to be 8 weeks from date of receipt of appellant brief, but now it has been reduced to 30 days. Yes, 30 days from 8 weeks to 30 days. Appellant brief from 10 weeks to 45 days. Respondent brief from 8 weeks to 30 days. Now, if you now have a reply brief, if you feel there are new issues you want to file a reply as an appellant, you now have 14 days to file your reply. Very important. So this is very key. You know, if you don't read these rules, you won't know these innovations. And if you don't know these innovations, there'll be trouble. By the time you get to court, you'll be tossed out. Now, it's also very important that just like the Court of Appeal rules, the Supreme Court will also make provisions as to the font they want the typed words on your brief, Roman or Tahoma with a 14 size. No, 14 size kind of makes it eligible. 14 size and at least 1.5 spacing. Now, it is important to note, just like in Court of Appeal, if your brief does not comply with either is in Arial, Tahoma, or New Times New Roman, they will not accept it for filing. So once you have to, this is very key. If you own a firm or you're in charge somewhere, you need to let your the secretariat know that for the fact is Supreme Court, anything you're typing that is Supreme Court, font 14, 1.5 line spacing, and the font to use is very, very key. I say that if it does not comply with it will not even be accepted in the registry for filing. Now, another thing you need to also know is the fact that by Order 16 Rule 7 Sub 1, sometimes you file a matter where there are a lot of parties and maybe their interests are similar, or they have identical interest. So by Order 16 Rule 7 Sub 1 of the rules, all parties whose interests are identical or joint shall file joint briefs, and separate briefs may be filed by parties whose interests are what separate. Order 16, Rule 7 Sub 1. Order 16, Rule 7 Sub 1. Let me read it out for you so you can hear it. Order 16, Rule 7 Sub 1. All parties whose interests are identical or joint shall, mandatory, joint briefs. Separate briefs may be filed only by those parties whose interests are separate or are in what conflict. Now, sub 2 now stated that where there are more than one appellant and they file more than one brief, it may not be necessary for the respondent to file more than one brief. This is talking about where the appellants are more than one and they file more than one brief. It may not be necessary for the respondent to file more than one brief in respect of his own case, and time does not begin to run against him for the purposes of filing his brief until all the briefs by the appellant have been served on him, unless the time within which the appellant may file their brief has what expired. This is very important. Go back and get a copy of these rules and read it through. A lot of new things have been introduced. Just and if the appellant, you say that the respondent needs to receive all the brief before his own time, time begins to run against him. Now, let's also note that there's another significant change that was introduced with respect to filing of briefs. Before now, in the appellate court, if a party, for example, the appellant, you filed your brief and the respondent did not file the brief, you can bring a motion to the appeal uh, for that the I'm very sorry. If the appellant, for example, didn't do the needful, transmit record, do what they are supposed to do, and all of that, a party can bring an application that the appeal, you know, uh, be struck out for want of diligent prosecution. Before now, you can file that motion, take a date to be moved, and all that. All that was advised that if an appellant fails to file his appellant brief within the prescribed period, the Supreme Court may dismiss the appeal in chambers. Yes. Either upon receiving a certificate from the registrar or from the respondent's application. That means it also behoves on issue of a legal administration. That means the registrars or those in charge can be going through the files for the week and notice that this person, if he did not file, there's no need, is not, and time within which to file it has elapsed. The registrar can, by a certificate, let the justices note that this appellant was supposed to file the brief but has not, so the appeal can be dismissed in chambers, whether the respondent files a motion or not. But if the respondent also goes ahead to file, such application can be heard in chambers. So there's no need to come and get a date to hear that a motion to strike out the appeal for want of diligent prosecution, or all the way someone will have to take a flight of almost 600,000 just to go and move that motion, or someone travels long distances. No, so this helps for efficient justice delivery. So once in going through the files for the week, the registrars or those in charge notices that the appellant has not filed the brief and time has elapsed, they will just notice this one have not filed. So I've not filed the brief. So the justices can even dismiss it in chamber without you filing your motion. But even if the respondent who is diligent files, it can also be taken in chambers without coming to open court to take motion to strike out an appeal for want of diligent prosecution. So this is a very important. You must also note that the timelines have the earlier timelines are stated about time for filing of briefs and all of that. It does not relate to criminal appeal in with respect to kidnapping, note, corruption, money laundering, and human trafficking. Because this trafficking, money laundering, they have been classified as fast track under the fast track appeals. You can check it in order 14 A of that 2024 rules. So the timeline